Good morning. I'm Lucy Beadnell with the ARC of Northern Virginia, and we are very excited to be joined today by Jen Crane and Liz Gray, who are attorneys and so graciously volunteered their time to talk about an issue that we know is huge in the Northern Virginia area, and that's navigating this complicated intersection of federal retirement benefits and how those intersect with benefits that keep people with disabilities alive. And how do we make sure that we're eligible for the right things at the right times? And so we've got the right people in the room here today to give us those answers. So I'm elated to turn things over to them. If you're watching this recorded in the future, know that you can go to the arcofnova.org anytime. And right at the top of our webpage, there's a click link that says information and referral, and you can send us questions or ask for copies of the slides or things like that. We want to make sure we're always accessible for folks. So without further ado, Jen and Liz, we cannot wait to hear from you. I will turn things over to you all.
Thank you. Thank you, Lucy and Diane. Before we get started, I just wanted to mention that Jen and I do this work because we love working with the families. And when we're talking about these benefits, we are generally talking about when you, as the parents, are gone. You're not here anymore. Because while you are alive, you are the special needs trust for your kids. And they're well advocated for by you as the parent. So what we're talking about are benefits and planning ahead for when you're not here to protect them. We're going to start by going over some of the other government benefits because you won't understand how the federal employees' benefits work unless you understand the whole public benefit criteria.
Absolutely. And I sent Lucy a message. I can't screen share yet, so hopefully we'll get that in a second so we can put up our beautiful slides that everyone will get when we're done. Liz and I are delighted to be with you today. We wouldn't be lawyers if we didn't offer the quick disclaimer that none of this constitutes legal advice or creates an attorney-client relationship as between any of us. But we do want to talk to you about the benefits. And one of the big things we want to cover, it's not in our slides, but we wanted to spend a minute on it, is that the federal survivor benefit annuity is different than the military survivor benefit annuity. That annuity, we have federal legislation for that allows us to transfer it to a first-party special needs trust so the income and the resources are not countable against your child. This is different. And so one of the things Liz and I would love to remind everyone is to contact your legislators about getting legislation for this. We are in the DMV. We are in a very unique position to be able to contact our congresspeople, contact our legislators, because we need legislation for this just as much as the military needed it, especially being in DC, which is the focal point of the federal government. So with that, as Liz mentioned, let's talk for a moment about benefits. Most of you probably already know this, but it's a great starting point. We're talking about means-tested benefits right now. Means-tested means income and asset limitations in order to receive it. Liz, can we see the screen okay? Can you see it?
I can see it.
Okay, wonderful. You're the only one I can see that's not a black screen, so you're my guinea pig. The first one we want to talk about when we're talking about means-tested benefits, we're generally talking Medicaid and SSI, and you're going to have to forgive me because I talk with my hands all the time. Medicaid provides basic medical care to low-income individuals. Most states also have waiver programs for residential, daycare, career, and other services. Now,
Jen, one of the things that people always ask me, they're confused about the name waiver. Why is it a waiver?
Well, and I'm going to ask you to chime in with me. It's a waiver service because despite the income and asset limitations that may be there for mom and dad, we can still get into it.
And in addition, it allows the state to keep the person in the community rather than institutionalizing them.
Absolutely.
So Virginia is waiving that requirement to institutionalize somebody.
Which is obviously a big thing for most of the participants on the call because we want our kids at home. And when we talk about, Liz, I know we don't have this in here, but I think we should talk about deeming for a second, because I think that's also a really important concept.
Yes.
Generally, our kids aren't eligible for benefits when they're under the age of 18 because our parental resources are deemed to them. We have a parental duty of support. So if we have to support our kiddos, why should they be getting benefits? Now, there are exceptions to every single thing Liz and I are going to tell you today. But when we talk about waiver services, that's a huge one. So you'll say, but Jen, my child is under the age of 18 and getting waiver services. Right, because there's certain ones that they are eligible for despite parental deeming. When we're talking at the big level, though, about means tested benefits, and we're talking Medicaid and we're talking SSI, especially SSI is for most folks on this call, not going to kick in for your kiddo until they're 18. At that point, your income and assets are no longer deemed to them, so they're eligible. Now, the SSI payment amount for 2023 is a whopping $914 a month, which isn't going to get you a whole heck of a lot in Virginia. But Liz, why do we want SSI even if it's only $914 a month?
We want that because further on down the line, when mom or dad who have paid into Social Security retire or then die, the child will get that higher Social Security amount. They will not get it unless the child started with SSI. What I mean is that the higher income amount that the child gets will not count against them.
Yep. Exactly. And if we're looking at mom and dad's work history, Liz, correct me if I'm wrong, but when mom and dad retire, we get 50% of the benefit, and at death, isn't it 70%? That's going
75.
to 75. It's going to be a much, much higher amount, and we're going to want to capitalize on that. SSI requires that disability determination. That disability has to be there before age 22. You want to get the SSI, even if it's not really going to contribute to what you're doing for your child each month. There's no way $914 is going to provide for their shelter and their housing, but you want it for what it'll give you.
And I hear from my clients all the time, well, we don't need the 914, my
Yep.
son lives at home, we pay for everything, we don't really need it. And we know you don't need it because it really doesn't pay for that much. But we want you to get your child to get the childhood disability benefits at the full amount and not have it count against them.
And I think that's the bigger thing is we're not planning for just right now. We're planning for down the road. As Liz mentioned, you are the special needs trust. Mom and dad are the special needs trust. When you die, we have to capitalize on everything that's available to us. And if we've got those means tested benefits, we need to capitalize on those. We also want to capitalize on the entitlement benefits. We talked means tested, income and asset limitations. Entitlement is exactly what it sounds like. You paid into the system. It's something you are entitled to and your child is entitled to by virtue of having worked. So our next slide is going to be on a quick review of other government benefits. And I'm going to turn this piece over to Liz.
Thank you. So childhood disability benefits is a Social Security program that provides cash assistance based on the Social Security contributions of the disabled child's parent, so long as the child is found to be disabled before reaching the age of 22 years. And the benefits become payable when the sponsoring parent retires or dies. And this really does have huge impacts. I had a client come in and her husband, who's the federal employee, didn't have his child until he was 48. So when he retired, his special needs daughter turned 18 and she immediately got Social Security disability based on dad's record. And that means that she will never get CDB. That's not going to count against her. So any means tested benefits that she wants, she's going to have over income. And that's a huge problem.
And Liz, do you want to talk for a second about the interplay between the CDB and the SSDI? Because I think that's a huge point of confusion.
Sure. So SSDI is Social Security Disability Income. And that's something that you get if you've worked and paid in, because it's an entitlement. You get that back if you're found to be disabled. The criteria is a little different, and you don't have to show disability before the age of 22.
And then what about, we think about the big ones. What about the little ones we want to keep in mind?
This was my idea, so Jen's making me talk about it, but there are a ton of other benefits out there and we never talk about them. But SNAP is a big one, Supplemental Nutrition Assistance Program. The eligibility guidelines are similar to SSI. You have to have really low income and $2,000 or less in assets. And they give you a credit card these days, which is great, because I hated when you'd see people with the little coupons, because people used to make snide comments and things like that when I was in the line, and it's much better not to be able to see what they're using to pay for the food. But it's a great benefit if you need it. Section 8 housing, which is now called voucher, and it subsidized the residential rents for families with low income. I had a woman who moved here from California. She was special needs, and I think she was 60, and she hated living with her sister, and she complained all the time. And so we got her a subsidized housing and a waiver. And so she moved into this really nice apartment in Arlington that was in walking distance to the grocery store, the library, at that time, the video store. I mean, it was really close to everything. And I thought, this is really nice. She's really living a nice life.
Living her best life, right?
Yeah.
And that's the goal, is we want to, it's hard making I don't know, Liz, I hear all the time, I don't want benefits. I don't need them. My child, because there's a stigma associated with it. There shouldn't be. You've paid your taxes. You've paid into payroll. These are things that, we can use to benefit your child, because when you're not here, we have to look at every other source we can to make sure your child has that quality of life that Liz was just mentioning.
And nobody else is going to advocate for them the way the parent does. This just helps anybody that's stepping in to help your adult child maximize what's out there.
Yep, absolutely. And one of the reasons why, when we use an organization like a pooled special needs trust like the ARC, when they're cognizant of all of these different benefits and the interplay between them, Liz and I would be remiss if we didn't say, when you're doing your planning, it's not enough to just have that special needs trust. You have to make sure whoever's administering it knows how it works and knows what all of the different benefits are. My running joke is, if they don't know the difference between SSI and SSDI, it's not going to be a good choice, because all of these benefits interlock, they dovetail with one another. And just because when mom or dad die, say we step up to SSDI, or we step up to any other benefit, that doesn't mean we're going to lose the means tested benefits we already have. So we have to be really cognizant that they often go hand in hand. So let's talk about, go ahead, Liz.
I just forgot what I was going to say. Never mind.
When it comes back.
When it comes back to me.
The reason we're here to talk about is this retirement benefit annuity. And we're going to go over both of them. So first, we're going to talk about FERS, which is the one that most people are now going to be on after we have the shift. And I think it was 1983. So this is the current system for federal employees. Monthly benefits are not payable to children of deceased FERS employees if the death occurs before the employee left the federal government and before retirement. So I have less trouble killing off my husband, so that's generally what I do. He's a federal employee. If he dies now, our kiddos aren't eligible for anything because he died before his retirement kicked in. So you've got these two factors you have to meet first. We meet those factors. A monthly survivor annuity is payable to an unmarried, disabled dependent if the disability, as certified by Social Security, occurred before the dependent child attained the age of 18. So Liz, would this be an instance where we want to make sure we have that SSI for the disability determination?
Yes.
How hard is it to go back and try to prove it 30 years later?
It's so difficult. We see some of the worst cases because the courts refer situations to us, and it's heartbreaking to see somebody in their 50s who's special needs and mom and dad died in their 80s not planning ahead. And one of the important things is to keep in a notebook all of these eligibility criteria documents so that you can easily pull the Social Security letter that says your child is now qualified for SSI or Social Security disability or whatever the benefit is. You need to keep those letters. If you're having a sibling of your special needs child take over as the guardian, they need to know this stuff, and they probably don't want to learn it now, but sometime or other they're going to have to find this stuff. And so keeping it in a notebook is a really good idea. The other thing I wanted to mention, I did remember what I was going to say. With the special needs trusts, we see a lot of people, I know Jen does too, that call us and they say, I already have the special needs trust, so I'm all set. No, you're not all set. You have to have a way of getting the money into the special needs trust from your estate. So you need to do your estate planning to make sure that any benefits that you want to go to the trust are going from your estate into the trust.
Absolutely. And it's, I joke a lot because this is a heavy area of law, but it's one thing to say you do special needs and it's another thing to do special needs. The number of times Liz and I have seen a special needs trust that say gives the beneficiary what's called a 5x5 power so we can get tax benefits. Nope. You need to actually meet with a special needs attorney that does this to make sure the trust does what you think it does, which is a deviation. Liz, what I wanted to mention when you talked about the notebook, one of the things you taught me is the memorandum of intent and how important it is to lay all that out. Can we take a quick 90 seconds for you to mention that?
Sure. So that's really the memorandum of intent or letter of intent is really all of the medical information, the public benefits information, and your personal wishes and wants for this child. I know, having acted as trustee, it is really hard to decide whether or not the beneficiary should get some item or not. And it's so much better if you are able to find out more about what this child means to the parents and what their goals were. I have a nephew who is special needs, and I know that he really is into CDs, even though I guess now he's into Rhapsody or whatever it is, but he had a huge wall full of CDs and he would rearrange them by genre or alphabetical. He loved them. And I know as trustee, I have to let him get whatever music he wants, because that would definitely be in my sister's memorandum of intent, that she doesn't want him limited. It gives him such joy. Allow the trust to buy this music piece for him. So that's really the memorandum of intent.
Excellent. When you mentioned just keeping everything together, I thought just a nice opportunity to remind people to do that. So back to the FERS system and the annuity that's available. The amount for 2023, I apologize, my eyeballs are on my second screen, is $635 a month per child. Maximum benefit is $1,905 divided by the number of eligible children in the event you have more than one child who meets that criteria. If one parent survives, and $763 a month per child, maximum of $2,289 divided by the number of eligible disabled children if the child is orphaned. This amount does increase with cost of living adjustments, and it is provided by law. An employee or retiree does not need to elect it. Okay. Oh, I keep going too fast. Okay. I get too excited. Okay, Liz, do you want to talk to us about CSRS?
Yes, and there are probably not that many people that are still on CSRS, but we should mention it. And it is.
We had one.
Oh,
You and I, well, I can't say now, but you and I had one that was on CSRS and we had to learn all the old rules.
You're right. We did have one.
We had one. So that means there may be one person on this call who needs this.
That's right. And it's the previous system for employees who started employment before 1984 and elected to convert to FERS, except for the employees that elected to convert to FERS. You had a choice, and some people chose to stay with CSRS and some people chose to elect FERS. It's a monthly survivor annuity payable to an unmarried disabled dependent if the disability occurred before the age of 18. That's for both FERS and CSRS. So remember what Jen said earlier, that it is really hard to go backwards to prove that your child was disabled before the age of 18 if you haven't applied for SSI at the age of 18 or before 22. And that's another reason why it's really important to get that SSI determination as quickly as possible as your child turns 18. Lump sum benefit. So CSRS is a lump sum benefit, and I'm looking at my other screen too, payable to an employee after the employee dies. There's no survivor annuity based on death. Oh, I'm sorry, I got that mixed up. Is a lump sum benefit payable if an employee dies, and no survivor annuity is payable based on his or her death. The retirement contributions remaining in the deceased person's credit in the CSRS plus applicable interest and COLAs. So the rules on how long survivor benefits can be paid to children under FERS is the same as under FERS, with one exception. Unlike the CSRS law, the FERS law allows reinstatement of benefits to a disabled child over the age of 18 if OPM finds that the child, after being removed from benefits for providing his or her own self-support, has again become incapable of self-support. So in CSRS, if your child is able to get a job and earn enough money for self-support, and they take him off of the annuity, and then something happens and they become disabled or unable to provide for their self-support, FERS is the only one that will restart and not CSRS.
And again, we've got a couple issues with this. And as Liz mentioned, we're not going to have a lot of folks anymore because we're talking the 80s, mid 80s. But number one, if that lump sum becomes payable, we're going to be over-resourced. And number two, the biggest thing is everybody knows the federal government is the gold standard for health insurance. Everybody wants that. Health insurance is like a black Amex card. You can go anywhere with it. And so you want that coverage to continue for your child. And the case that Liz and I had, we're on the CSRS system. We've got somebody from, a long, long time ago, did not convert, wanted to make sure their child kept the health insurance. And this is a big thing to talk about because there's different rules as between FERS and CSRS. With CSRS, if the child did not take the annuity, the regular payments, the premium was not going to be paid for the health insurance, and we couldn't pay the premium from another source. So you either had to keep the annuity payment to keep the health insurance, or both of them went poof. Under FERS, it's different. You can keep the health insurance, and if the monthly annuity payment is not enough to cover it, you can pay it from another source. Liz, why is this so important, especially right now?
I don't know.
Do we have, so if we can divert for 10 seconds, maybe 15.
I don't know where you're going.
I don't know where I'm going, about the sheltered workshops and how we're changing how income. We have to keep it. It is wonderful. Working gives us self-value. It preserves the dignity of the person. We have to be cognizant of benefits though. And working too much can either over-resource you, or Social Security can say you're not disabled anymore. You're able to engage in substantial, gainful activity. You don't meet the definition. So when we talk about that FERS annuity, let's put CSRS to the side for a second. We have to worry about being over-resourced from an income standpoint. We can take that monthly annuity payment and stick it in a special needs trust, but we can't do anything about the income potentially being disqualifying. And if we've got to maintain the health coverage, which I don't think anybody would advocate dropping the federal health insurance, but we have to make sure that the annuity payment is not so much as to over-resource us. With FERS, Liz, can't the parents elect not to take the actual annuity payment and keep the health insurance?
They can, and another source can pay that premium. So one of the things with FERS is that you are also eligible for Social Security benefits. And the amount that the child gets in Social Security is deducted, or actually the first payment is actually reduced based on what the Social Security payment is. And that means that in a lot of cases, there's zero coming from FERS, but the person still is getting the federal insurance benefits.
But if we have CSRS, that's it. If you have to keep the annuity payment in order to keep the health insurance. And so then we have to figure out, okay, what are all our income sources? How are we going to plan around this? Because as we mentioned at the very beginning of the webinar, we don't have federal legislation that protects these payments. Now, it's wonderful the military does, and that helps a huge swath of people, but we also have the same issue for federal employees. So to have that same legislation would be a tremendous boon to the special needs community and give us a better opportunity to plan and to help people stand up on their own. So one of the things to keep in mind is, how are we going to maintain the health insurance? And that's why when you sit down to plan, all of these pieces have to come into play. You have to tell whoever your kids, whoever you're working, all of this. Because if they don't know all the pieces, there's going to be unintended consequences. Once we have these benefits, we don't want to lose them. Not even just the disability determination. If any of us have had to interact with the federal government, you don't want to do it more than you absolutely have to. So making sure, which system are we under? How is it paying out? Are we keeping the insurance? Do you remember what you elected on the form? That's when I ask a lot. Did you check off spouse and disabled child? Because you need to know. That way it'll help you better plan.
For example, you can check not to give the disabled child any benefits because you know what the issue is with being over income.
Yep.
And one of the things that a lot of people don't realize is that in order to get the housing piece, if you go over to the Community Services Board and say, my adult child with disabilities is really high functioning, he needs a group home, and I want to get him on the list, they'll laugh at you because you don't get on that list unless
Jen
you're
just
on
laughed.
a Medicaid waiver. You
Mhm.
have to qualify for the waiver in order to get the housing. And then I have a lot of parents, I'm sure you do too, Jen, that say, well, I'm just going to keep my house and my child can turn it into a group home.
Please don't do that.
That doesn't work.
No.
It's really difficult to get a house determined to be a group housing place. And oftentimes the house is too big for the adult child to live there alone.
Mhm.
You don't want to have a roommate situation because then you're dealing with tenants and all of that and the liability issues. And the cost and upkeep of this house may be huge
Mhm.
with not enough money to pay for it.
That's one of the things, and I understand the tendency. We will buy a house, Johnny will always have a place to live. But what folks don't think about is the expense associated with it. And so most trusts, and the ARC is very unique in this, the ARC will take real estate now, but they run a whole projection on it to make sure that the corpus of the trust, the amount in it, isn't going to be completely overtaken by the upkeep of the house. And so when we sit down and have that conversation with families about, let's understand exactly what this means, oftentimes we come to the suggestion of maybe keeping the house isn't the best idea. I had a family that wanted to keep the 6,000 square foot family home in the trust. And the only way they decided maybe this wasn't a good idea is we had the financial advisor run a projection of just how much money was going to get eaten up by the house. And so all of these get back to planning considerations, making sure we know what the plan for Johnny is, where is he going to go, and how are we going to pay for it. And then this piece of it, I think, Liz, our tendency, most of our families, let's just maximize the amount of money. But we have to be careful that maximizing the money doesn't inadvertently cause a benefits problem. Now, Liz, the other question we get all the time is, well, I'm leaving $1 million for Johnny. What could public benefits possibly pay out that he wouldn't already have by virtue of that $1 million?
Well, if you look at even the tax payments in Fairfax County, $6,000, $10,000 a year for just real estate taxes. And then what about upkeep and maintenance? What if the house needs a new roof? What if there's no lawn care and neighbors are getting really angry and your homeowners association sends you a nasty gram? Things have to happen with a house and it has to be maintained.
Yeah.
I had one client who had $1 million in the trust and wanted the trust to buy her a condo. And she was looking in Fairfax County and she found this $750,000 condo that she wanted the trust to buy for her. And so the trustee did a calculation and said, we aren't going to have enough in this pot if we pay $750 out of $1 million to provide for the upkeep and maintenance for the rest of your life. So we won't go higher than 600,000. And a very disappointed person because she really wanted to stay in Fairfax County. It meant she needed to go further out and the benefits weren't as good. So
It's always, one thing let's look at other housing alternatives. Let's not focus on owning property. How can we give you that assurance, that security? If we can run that same financial projection to show, here's an assisted living, here's an apartment that the trust can pay for. We are guaranteeing Johnny's going to be okay. He's always going to have lodging, but we're doing it in a way that doesn't jeopardize the value of the trust. I think too, as we're starting to see a lot of new conditions where we don't know how much things are going to cost, we want to be more conservative in that planning. I have a tremendous number of families now with Fragile X, and that is so all over. We can't do a great job figuring out how much everything is going to cost. So thinking about those housing considerations, what are the sources we have to pay for it, and making sure everything is properly set up. So we're going to talk about an example, and we've kept the numbers low because Jen can't do math.
neither
So,
can Liz.
okay, so my running joke is I went to law school because I can't do math. So here we are. Claire and Jamie are married with an adult child, William. He has special needs and receives SSI in the amount of $914 for 2023. No reduction for in-kind support and maintenance, even though William lives with mom and dad and signed a lodging agreement. Liz, let's talk about a lodging agreement for a second and why this is so gosh darn important.
So Social Security SSI was originally designed for food, clothing, and shelter. Years ago, clothing was removed, and so now it is used to pay for food and shelter. But Social Security says, well, if you're getting shelter paid for by somebody else, you don't need all of this benefit. We're going to take away 1/3 of it and only give you 2/3 because you don't need housing anymore. So what we do is a lodging agreement, and I call it a lodging agreement. I think Jen does the same thing. We practice very similarly. Because I don't want to call it a rental agreement, because I've had clients come in and they are dealing with the tax issues with a rental property when this is not really rent in the IRS eyes. A lodging agreement is really the child reimbursing you for expenses. And I've talked to other CPAs and they agree that it is not taxable income. It is really truly reimbursement. So don't get confused by calling it a rental agreement and call it a lodging agreement. And if you show that to Social Security, when you apply for benefits, you'll get the full amount without the 1/3 reduction.
And the lodging agreement, and, as with everything, talk to your CPA to make sure that your situation fits with this. The lodging agreements are hard for people to stomach because there's a line in there that says, if Johnny doesn't pay the rent, I'll kick him out. And I've had a couple families come back and say, I won't sign this because I wouldn't kick him out. I understand you wouldn't kick him out, but if this line isn't in there, Social Security isn't going to accept it because it's in-kind support and maintenance. The purpose of the agreement is to show that this is only an arrangement that would be extended in exchange for money. And that's how we show we still need that 1/3. We don't want the amount reduced. So it's one of those things, it's definitely difficult. And I try to tell people up front before they see it, this line is in here. And if you choose not to sign it and take the 1/3 reduction, everybody has to do what's best for them. You have to operate on your own belief system, but that's why it's there. If you were renting me a room, Liz, and I couldn't pay, you're not going to let me stay.
You're out.
Yeah, I gotta go. So that's why it's there. And I'd rather have a rental agreement than nothing. I'd rather have something in place, but it's showing if this is the money that's designed to pay for now William to stay in the house, here's why we need the full thing. It's because he does actually have to reimburse us for the cost of living in the home. And then, of course, things are changing again because now there's a movement to remove food from the I feel very old now that like I've been here for clothing, now it's food. We'll wait and see how that pans out. So he signed this lodging agreement. So, oh, but I'd like to offer a caveat. If you did a rental agreement and Social Security has already accepted it, you may not want to dance with changing it, because if they've accepted, just let it be.
Let it go.
It's just, however much you're charged, just let it be, because the chances of them rejecting it if you change it are higher. So we can't, I tell everybody it's a series of levers. We can't get all the levers to even. We do the best we can.
And
Okay.
sometimes this whole thing about whether it's 914 or 500 something with the 1/3 reduction is really, when the income comes in, it's considered income for SSI and for Medicaid. If it stays there for the next month, it becomes a resource. And remember, this child can only have $2,000 or less in resources. So sometimes it's really designed to keep that low enough so that you don't go over that $2,000 all the time. So it's not such a bad idea. And the payment, so when the Social Security payment comes in to the rep payee account, you pay a check to yourself for whatever the rent is. If it's $500 a month, you pay that to yourself. Once it's in your bank account, it's your money. So if you want to further put it into a trust or something else, go ahead.
Yep, absolutely. If you are doing this as a rental agreement, be super duper careful about claiming any deductions, because then if you get audited, the IRS is going to say this isn't fair market value. You are not charging, especially in Northern Virginia, what you should be for rent. So that's why I always caution, please talk to your CPA and let your CPA make those decisions, because they'll know what your entire picture is. So, okay. Claire is, I love this though, because no, this is so important. It all dovetails.
Yeah,
all dovetails.
It's all related.
Claire is employed in the private sector, but Jamie is a federal employee. If Jamie dies first and Claire is living at his death, he's a federal employee, William's benefit would be $635 a month, because we're under the FERS system. So while Claire is living, we subtract $20 in the income exclusion. We get to keep that $20 from $635 to get $615. Then we subtract the SSI amount to get $229. Therefore, William receives $635 from OPM, $299 from SSI. And Liz, that's because the systems are intertwined, correct? Because we have paid into Social Security under this scenario.
That's right. Absolutely.
Okay. Now, so this is let's make it even more complicated. Let's say William works, because why should we keep this easy? If William works and earns income, the first $65 of earnings is excluded, and then the remainder is divided in half. So that's the SSI amount he receives. So in that case, oftentimes we won't receive the SSI. Now, Liz, I'd like to deviate for a moment. We're in Virginia. Does it matter if we don't get SSI and we are receiving Medicaid?
It does not matter. So states get to choose whether they're a 1634 state or a state that links SSI with Medicaid. And there are a lot of states that do that. You must get at least $1 of SSI in order to keep your Medicaid benefits. I had a colleague from Vermont, which is a 1635 state, and they were really worried about coming to Virginia. And it was really a non-issue, because in Virginia, you can have SSI and no Medicaid, or Medicaid and no SSI. They are separate applications. You can get one or the other. They're not linked. And this is really going back to the laws that were set up and the code sections we mentioned when we call it a 209B state, which Virginia is, or a 1634 state. And that's because the criteria for SSI in Virginia is much more stringent than it is for Medicaid. So if you qualify for SSI, you will qualify for Medicaid in Virginia, but they're not linked like the other states.
And that's what's so important. As Liz said, you'll qualify, but it's not automatic. So just really, really important for people to know that.
Well, and you know, we're talking about Virginia, but people move all over the place these days. And what if your adult child, when you're gone, moves to another state? We want to make sure that they get the benefits that they need to live a good life.
And that's the other thing when we're talking about planning and that special needs trust is the consideration of what if Johnny moves? What if Johnny is going to he's going to move to Wisconsin because that's where his brother lives? We have to make sure the trust is portable. So when I say that, because the benefits rules are different in every state, you want to make sure the trust can move with him. I like to tell folks the Constitution promises us valid where executed, valid everywhere. Do you really want to pay a lawyer to fight that fight about the Constitution with the benefits worker in Wisconsin, or make sure the trust has a mechanism to be updated so the situs is Wisconsin? Because once the trust is funded, Liz, if we're getting benefits, who needs to see the trust?
Social Security and Medicaid.
Yep.
So Virginia, that's DMAS. And we usually help the clients in disclosing the trust because you can get in big trouble. We just had a case like that before, I think in December or January, where the person forgot to notify. She didn't realize she was supposed to notify Social Security and Medicaid about the special needs trust. So it immediately became a huge issue. We ended up having to go to court, and that was outrageously expensive for the family. And I wish it hadn't been necessary. But it's always important to talk to an attorney that understands the special needs planning piece, so that if you're having a standalone special needs trust drafted, that you can transport it anywhere. And when it kicks in, if it's a third party, that it is actually disclosed to Medicaid and Social Security. And I just mentioned third party, and I'm sure I confused everybody. So Jen, you're really good at this. Why don't you explain?
Well, and that's one of the reasons I want to say quickly why I use pools all the time, especially for my military families, because it's going to move with them. It's not going to be a problem. Also, practically speaking, when we have a standalone trust going into Social Security for approval, or the ARC is sending a stack of now funded trusts in for approval, those are going to get approved much more quickly. They're not going to be looked at with the same level of rigor that the standalone is. And as one of Liz's and my colleagues says, benefits workers are tired, overworked people. They are not going to dive through that trust to find every reason to accept it. They're going to dive through that trust and find the first thing that disqualifies it. Nope, we're done. I want to make it easy for them to accept it. So let's take a quick second and talk about first party and third party. Here we go with my hands again. First party is the beneficiary's own money. So if they win the lottery, personal injury settlement, it's their own money. In nightmare scenarios, it's an inheritance because we haven't planned appropriately to get it into a third party. Third party is somebody else's money. So if my husband and I create our estate plan and we put a third party trust in place for our son, that money is ours. It's held separate and apart. It's never Joe's money for purposes of determining his public benefits eligibility. Why does that matter? Well, first party over here on my left hand has a mandatory Medicaid payback. So at the time of Joe's death, any place, any state that has paid Medicaid benefits on his behalf is entitled to repayment. Now, for the federal authorities listening in, I am all for paying Uncle Sam whatever Uncle Sam is due. We want to pay back those costs, but we don't want to pay things that we don't have to unnecessarily. Who here is kicking in more money for the federal government on their tax return because they think they need it? Probably no one. If
But I
mom
always
and
tell people that if you think about it, though, it is really a good deal, because
Mhm.
if you got benefits in 1990 for a huge operation under Medicaid, you're still paying it back at what the cost was in 1990. There's no
Yeah,
interest, there's no penalties, there's no increase. It's still at the 1990 rates. So in a sense,
absolutely.
it's not that bad.
Absolutely. But where I cringe, or as I say, twitch under the table, is where mom and dad didn't plan. So it's not going into a third party. Liz and I can still catch it in a first party if the beneficiary is under the age of 65 and if we bring it to us. But the number one, we've probably already lost benefits at that point, depending on when we're contacted. And now we're subject to that Medicaid payback that we would not have been if we had planned with the third party. Now, I always say that the survivor benefit annuity for the military, because that's the one that can be assigned, it doesn't make right. It's mom and dad's military record that's allowing this annuity to be paid, but it's still first party money. So it has to go into a first party trust, and there's a whole procedure for it. We set the first party up, we notify DFAS, there's a certification each attorney has to do. And then that way, when that military annuity pays out, it goes directly to the first party trust. The other thing to keep in mind, we can't combine first party and third party money. So a lot of folks are going to have two separate trusts. And it's really important for that first party, if we have the military survivor benefit annuity flowing into it, to remember that's a monthly payment. It's going to take a long time for that trust to accrue a corpus. And the reason I mention that is in Virginia, trusts are considered uneconomical. That means more expensive to administer than the trust is generating in money, in income, at $100,000. So when you're planning, if say you want to use a professional trustee, they're going to tell you, fantastic, we'd love to be your trustee. And then when the time comes, if there is not enough money flowing into it, they're going to decline to serve. So just
Yeah.
all questions to
We're
think
seeing
about.
that, we're seeing that more and more with banks and financial
Mhm.
institutions that used to serve under special needs trusts, but now if it's less than 2 million, a lot of them won't serve as the trustee. And that's another reason to push the Arc of Northern Virginia's Special Needs Trust. They will take $10,000. They'll
Mhm.
take 2 million, but they'll also take 100,000. And their fees and costs in maintaining and administering it are a lot lower because of the pool and
Yep.
because they're a nonprofit. So
And the
I'm always urging clients to look at these trusts as a really good option, because I would much rather have them use a pooled trust than have another child as the trustee of a standalone trust, and you ruin that relationship between
yep.
siblings, because the sibling turns into a parent to the
Mhm.
child, and there's a lot of work to do as a trustee of a special needs trust in making sure that benefits aren't ruined and taxes are paid and all that kind of stuff.
You literally become your brother's keeper. And that's not a situation that's, if you have more than one child, your neurotypical child, whether or not you know it, has felt resentment at one point. We have a medically complex child, and then we have four neurotypical children. And those four little girls do not understand why I spend so much time with their brother. And they say all the time, you love Joe best. Nope, Joe just needs me more. And so when you've gone and there's just those kids left, let your neurotypical sibling care for your child care for the person of their sibling, not file tax returns and keep records of everything they're doing. The other huge benefit to using an organization like the ARC is if you were sticking with the military, I know we're doing federal benefits, but I'm sticking with the military. If you have your first and your third party, you want them at the same place so that we can run down the first party first. If there's no money left in it at the beneficiary's death, there's nothing for Medicaid to recover against. We're not doing anything wrong. It's perfectly legal and valid. But that third party doesn't have a payback. It can go wherever you want it to go. So it can go to your neurotypical child or your grandchildren. So you want to keep things consolidated. This is not a time where we want to spread everything out and use as many folks as possible. You want it consolidated. You need whoever is running those trusts to be able to see everything. And that way they know what benefits they're working with, they know what they can expend, and they're just in a better position to serve your family. So we deviated to talk about first
Yes.
and third, but this is why write your congressman, women, write everybody, because we need this too. This is a huge thing in the special needs community, because I think, Liz, every time we get one of these, you and I sit down and try to figure out what to do, because every single one is going to be different. Every single one. Okay, so we're going back to our example. Assume William works part-time and earns $265 a month in income. We reduce that by 65 because that first $65 is excluded. Then we divide it in half and reduce the SSI amount of $299 by 100, so you get $199. I see people raising their hands. I'm assuming we're just going to do, we've got 22 questions. I'm assuming someone from the ARC will stop us when they want us to stop talking and answer questions.
We can
But I
do
guess,
that at any point, but what you're sharing is really valuable. And usually when we get into questions, we get into a situation that's pretty limited to the number of people. So I would certainly, take
okay,
the time you have to wrap things up. And then for whatever
okay,
questions we don't get to, if you and Liz can speak to other ways for folks to learn or get those questions answered, that'd be great.
absolutely. And I failed to say at the beginning, please don't share anything that you don't want every single person on this webinar and who sees it later to see, just because everybody will see it. So the biggest thing is when we're talking about FERS and CSRS. With FERS, because you've paid into Social Security, that amount is going to be reduced. So just make sure you're aware of that. Make sure if you want to keep the health insurance that you've planned for that and how that premium is going to be paid. So, I think those are the biggest things. Again, it actually in some instances helps us that Virginia is a 209B state, because we don't have to worry about that interplay. You have to keep, an overall viewpoint, but you don't have to worry about it. Liz, what did I miss?
I was just going to go back to the federal insurance benefits.
Okay.
When you're FERS and you pay into Social Security at 65, you could get Medicare.
Mm-hmm.
And when you're on SSDI, so Social Security Disability, after 2 years, you can get Medicare.
Mm-hmm.
For a lot of these adult children that we're talking about that start with SSI, eventually, if they get CDB or SSDI or some other benefit, they can have Medicaid piggyback on Medicare.
Okay.
And there are quite a few programs, depending on the income, that allow Medicaid to piggyback on Medicare, because let's face it, Medicare is much better than Medicaid. You have much better choice of doctors and services. So
Yeah. Should we do some of our questions?
Yeah,
yes.
let's
Wanna
take
go
a
ahead?
look at some of them. So we had an initial question about SSI calculations. So if we've got both mom and dad retiring, which parent's earned income into the system is used to calculate that child's SSI, especially because we usually have one of those parents who's a higher income earner.
Well, it's usually they don't retire on the same day.
Right.
So it's the one that retires first. So if dad has higher income and higher Social Security, then mom shouldn't do anything to trigger her taking of Social Security until dad either retires or dies. Then Johnny will get the higher dollar amount.
So we'll go on to the next one, and that's my daughter gets SSDI now, but her 20 hours a week job means she doesn't really get SSI because her income's too high. Does she still need to worry about this $2,000 SSI asset limit since she's moved from SSI to SSDI?
I paid a lot of money to learn how to say the words, it depends. It depends in each circumstance. So the first thing I want to caution about is working, we always have to be careful about the number of hours we're working, because both SSI and SSDI are predicated on an inability to work because of a disability. I'm not saying not to work, but just to be cognizant of it, because if you work too much, regardless of the money, SSI, Social Security is going to say you are not disabled. The definition hinges on an inability to engage in substantial gainful activity. So just be very, very cognizant of that. Now, the next question, Liz, I think both you and I would ask are, is there Medicaid here? Is it just Social Security or is there Medicaid? Um, so no, SSDI is an entitlement. You have paid into the system. This is something that we're getting back. But again, you still have to meet the definition of disability and you have to be cognizant of any of the other benefits.
I was just
And
looking up the substantial gainful income for 2023, and for a single individual, it's $1,470 a month.
Yep.
So if you earn over that month, you're not considered disabled.
something to know, and for anybody who needs it, Virginia has free work incentives coordinators who are experts in Social Security and how that intersects with work in specific. And to Jen's point, kind of like knowing ahead of time, planning ahead of time for things like that, enrolling in some work incentives programs can be a way to protect or elongate eligibility. Okay. So we've got another question here about how when parent retires and then ultimately their adult child switches from SSI to SSDI, does that affect someone's eligibility for their Medicaid waiver?
It does not, because like we said earlier, the child started with SSI. So there's I think this is pickle amendment stuff.
Yeah.
It's called pickle because of the name of the congressman. It doesn't have anything to do with the food.
But it was really appropriate, right? But it's a pickle. It's a pickle of a situation.
Yes, yes. So as long as this adult disabled person had SSI, the higher dollar amount is not going to affect their eligibility for waiver services under the income criteria.
Is there a specific document to document that the disability onset before age 18? Is there one particular thing I need?
I think when you submit everything to both, because you're going to have to do it in both places. Once you submit it and you get that disability determination, I think that's the one page Liz was referring to. Social Security will send you a letter saying you have been determined to be disabled as of such and such date. That's what you want to save. You want to save everything if you're me, because I don't want anyone to have to go back and recreate the wheel. But I think that, Liz, was the one page you were talking about, is the determination from the agency after you've submitted everything.
And what you're talking about, Jen, is the medical criteria, the medical
Yes.
documents. So
Yes.
you get that from the doctors and make a determination based on what the medical community says.
Yep.
We're at about our time limit here, so I wanted to give a huge thanks to Liz and Jen, who obviously know a ton about this phenomenally complex situation. How would you suggest folks who have questions proceed at this point?
People can either send us an email, and if I get an email, I'll share it with Jen, vice versa, and we'll
Absolutely.
decide who's going to answer it. And I think the last slide has our contact information.
Yep.
It does, and that will be emailed to everybody who signed up for today.
I would please beg people not to get on Google and look stuff up, just because the number of times I get, well, I Googled this. Cool. Okay. Let me tell you why Google was wrong. When you're looking for information, if you don't want to contact a lawyer, which obviously is our first recommendation, go to the Special Needs Alliance website, go to the Academy of Special Needs Planners. Social Security, I actually think the website is pretty user-friendly. I know that's insane, but there's a search function at the top that's pretty darn accurate. Whenever you're looking for information, just go to the source. You don't want to use anything that's politically motivated on the other side, because you're not going to get accurate information. Go to Social Security, go to the SNA, go to the Academy of Special Needs Planners. Liz, I think those are the big ones. Please don't use somebody's blog. We just can't verify the information. And what I think we get all the time is, well, I talked to my neighbor and my neighbor is doing bup, 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 bup. Your situation is going to be different than your neighbor's. So those are the big sources I would go to. Liz, did I forget anything?
You didn't, but I do want to mention the Special Needs Alliance. There is really stringent criteria to get into the Special Needs Alliance. So when I make a referral to a different state, I am looking in the Alliance webpage to find an attorney, to find that attorney in Idaho or Nebraska that is going to know enough information to provide valid and good legal advice on special needs planning.
Thank you all very, very much for being with us. We're so grateful for your time and your expertise. Thanks so much to the folks who joined us. And again, if you're watching this in hindsight, always thearcofnova.org and just click information and referral to ask us questions and get copies of things. Thanks, everybody, and we hope you have a wonderful day.